I am Edward Sparrow. I'm the chair of the City of London Law Society, and it gives me great pleasure to welcome you to the inaugural Gray's Inn and City of London Law Society's annual lecture. I'm only sorry we cannot be in Gray's Inn Great Hall. The idea for this lecture was mooted by the City Working Group, which is a cooperation between the Inn and the City, and was embraced by both participants as a means of fostering and developing closer ties between the Inn and City lawyers and airing common challenges. My first task is to introduce our speaker. In fact, of course, he needs no introduction to anybody here. For some of you, Ali Malek is Master Treasurer of the Inn. For others, a stylish advocate with incredible judgment. I'm sure we would all agree with that master creator of epithets, Chambers, that he is a star at the bar. That this lecture can take place at all demonstrates how far the bar has moved over my career. When I qualified in the late 1970s, the bar rules required that I ceased having the occasional lunch in Lincoln's Inn Hall with my father, who practiced there, for fear that members of the bar would canvass work from me. Gray's Inn itself has a record of innovation. I'm reliably informed by members of the Inn that when my father as treasurer was fulfilling this role and introducing an advocacy training course run by the Inn, he told the students how lucky they were. In his early days at the Chancery Bar, there was no such training. And indeed, in his words, mere audibility was regarded as an affectation. To be serious, the developments that Ali will predict, the challenges that he will say the bar and the Inn face, and many of the solutions he suggests apply equally to members of the City of London Law Society. The bar and city firms, and for that matter, the judiciary and others in the city, already work well together in the areas he identifies. The statement of the UK Jurisdiction Task Force on Crypto Assets and Smart Contracts was drafted by members of the bar and city lawyers. The International Law Committee, formerly the Brexit Law Committee, which has over the past 4 years provided unified legal advice to the government on the effects of Brexit on the UK legal system and professions, has members from both professions. However, we can and should do more together. We might start with a joint response to the consultation just issued by the UK Jurisdiction Task Force on digital dispute resolution arbitration rules, which Ali will refer to. Also, in the fields of diversity, social mobility, pro bono, and access to justice, I strongly feel the tendency to the fluorescence of individual initiatives is less effective than cooperation. I have said enough. Let me pass over to Ali. When he has finished, we will have time for questions and answers. Thank you.
Good evening. It's a great honour to give this inaugural lecture of the Gray's Inn and City Working Group. The working group was set up last year. It comprises members of the Inn and the City of London Law Society. Its mandate involves looking at areas of mutual benefit and interest, such as promoting the rule of law, the position of the city in the provision of legal services, promoting access to justice and pro bono work, and social mobility and diversity. The working group is chaired by the Vice Treasurer of the Inn, Sir Peter Gross, and meets on a regular basis. In this evening's lecture, I propose to look at the role of the Inn. I will look at the areas of mutual interest that have been identified by the working group and consider where the Inn fits in. The Inn is an institution going back many centuries. It provided lodging for lawyers as early as the 14th century. By history and by design, it has focused on the education and training of barristers. The aims of the Inn are detailed in its standing orders in these terms, and I quote, "The Honourable Society of Gray's Inn exists to support, educate and develop its student barrister members and to provide continuing professional development to its qualified barrister membership in accordance with its historic tradition. The Inn has a pastoral responsibility for its members and seeks to be a source of wisdom and support when needed. Call to the bar by an inner court is a gateway to practice as a barrister. The Inn provides not only education and training, but also financial support. A large part of its available income is spent on scholarships, support to legal charities, and awards. Although it's right to record these more traditional aims of the Inn, I propose to look at what else the Inn does and what it represents. For it to attain a wider relevance, the Inn's aims ought to be expressed in broader terms than the training and education of aspiring barristers. These are sufficient justifications for the Inn's existence, but the Inn can and must represent more than that. Moreover, now is an appropriate time to reflect on what the Inn represents, what it was, what it is, and what it might become. Although we might not fully appreciate it now, the world in which the Inn is operating is changing. The new world will present new challenges. How is the world changing? There are at least four matters that are relevant here. First, COVID-19. Because of the pandemic, for over a year, the courts have been conducting virtual hearings in a way that no one could have contemplated before. The way we practice law has probably changed for good. Even after the pandemic has ended, remote working of some kind is likely to remain. Secondly, alongside these changes to the legal profession, business is also changing. There are new technologies. Blockchain now operates globally, as does crypto assets and smart contracts. There is every reason to think that English law will play an important part, both as the proper law of these contracts and the jurisdiction where disputes will be determined, whether in court or arbitration. English judges and lawyers are rightly keen in the face of foreign competition to put English courts and English arbitration at the centre of those disputes, just as historically they took the lead on commercial disputes that in their day were just as novel. For example, the UK Jurisdiction Task Force, the body responsible for the 2019 legal statement on crypto assets and smart contracts, which is chaired by the Master of the Rolls, Sir Geoffrey Voss, has just last week published its new digital dispute resolution arbitration rules tailored to blockchain disputes and other novel technologies. Artificial intelligence is likely to change the way we operate. The challenge is always to take advantage of the technology without being overwhelmed by the data. Thirdly, there is a globalization that has made the legal world a much smaller place. There has been a fluorescence of international courts and arbitration centers, prompting new forms of interjurisdictional competition. Finally, there is a growing awareness of the importance of diversity and inclusion, and of our social responsibility to promote the same. A legal system that does not reflect the society it seeks to regulate is not fit for purpose. As we become more vulnerable to global influences, it becomes necessary to revisit core values which guide us, such as the rule of law and access to justice. What I propose to look at this evening are some issues that affect the Inn within this narrative. These issues affect the broader legal profession and are therefore relevant to all lawyers. If there is anything that is unifying in what I discuss, it is that the Inn and its members serve a public interest that is beyond simply the education and training of aspiring barristers. The first issue I cover is the role of the Inn in promoting the rule of law. It is in the public interest that the Inn and the legal profession are required to support the rule of law and their own integrity, the integrity of the legal profession. That is all well and good as an abstract proposition. The real issue is what this means in practice. I want to focus on matters connected to the rule of law, independent legal advice, and the independence of the judiciary. The first matter I want to discuss is the Cabaret Principle. It is a principle that is well known. It has a mixed press. Some regard it as fundamental to the way barristers act. Others say that the principle is a voluntary one because it is easy to find a way of avoiding it. I belong to the first school. This is because the Cabaret Principle forms part of the ethical duties of a barrister. A barrister must act fearlessly and without regard to his or her own interests. A common misunderstanding is to equate the lawyer with the lawyer's client. It is an aspect of the rule of law that a lawyer is not to be equated with a client and is not to be subject to pressure to reject an unpopular brief. This is not simply a rule that applies to barristers. It is reflected in Article 18 of the Basic Principles of the Role of Lawyers adopted by the 8th UN Congress on the Prevention of Crime and the Treatment of Offenders, and that was in 1990. And in the same year, the International Bar Association standards for the independence of the legal profession were adopted to similar effect. The idea that a lawyer is not to be connected to a client or its cause gives rise, and it also follows from the Cabaret Principle. There's been recent discussion as to how this principle applies in relation to work outside England and Wales. The Bar Code of Conduct indicates that it does not apply, and I quote, if accepting the instructions would require you to do any foreign work, unquote. And then there's a definition of foreign work. What this means in practice is that the Cabaret Principle would apply if a barrister was acting in for a party proceedings in London, but if the same party was involved in related proceedings, say in Cayman or Hong Kong, it would not apply. When one considers the recent growth of international courts, which I'll come back to, where barristers have the right or can seek to have the right to appear, and of the substantial international arbitration work done outside England, it strikes me that the distinction between English and foreign-based work, so far as the application of the Cabaret rule is concerned, is unprincipled and dated. This is even more so in the age of remote hearings, where international work can be done without any international travel. I would not exclude the Cabaret Principle in relation to foreign courts, where we're entitled to appear as advocates. When one considers a number of courts and arbitration tribunals outside England, where English common law or principles developed from or influenced by English common law are relevant, it is unfortunate to make a distinction between those courts and the courts of this country. I suggest that a better rule is that the Cabaret Principle applies to all foreign courts or arbitral tribunals, provided these tribunals are generally independent and apply rule of law principles. On this principle basis, it would apply to courts that would not apply to courts that act at the behest of the executive, as where there is what is known as telephone justice or directed decisions, or taking one step further, where the executive appoints friendly judges to get the result it wants in an individual case, or where the laws being applied to the foreign court in the foreign court are morally repugnant or contrary to international law. The second matter to mention is the clear public interest in an independent bar upholding the rule of law and supporting an independent judiciary. It is self-evident that the rule of law cannot exist without an independent judiciary as its custodian. Judicial independence has many aspects, including independence from anything that endangers decisional impartiality, independence from the executive governments, from special interest groups, and generally resistance to corruption. In modern terms, it must be considered to encompass diverse judiciary, which ensures that all interests in society are represented when judicial decisions are made, and more personally, that litigants feel that justice is not dispensed by only a subset of the community. Judges are frequently criticized and subject to unfair remarks, particularly matters before them where they're politically charged. The classic example is the abuse from a powerful but bad loser. Perhaps the best example of recent vintage is the bitter turmoil that followed the Brexit vote, when senior judiciary were described as enemies of the people by a tabloid newspaper for insisting that Parliament should be given a say on whether to withdraw from the EU, a curious complaint for a group of people supposedly intent on returning sovereignty to Parliament. But of course, the criticism goes beyond that particular dispute. Judges doing their job can never be enemies of the people. Because judges are independent, it is difficult for them to get engaged in debates. They deliver judgments, and these judgments are the last word. The losing party may be able to appeal to a higher court, but the judge cannot personally defend his or her decision. All that the judge is doing is applying an understanding as to what the law having received adversarial argument from the parties. The question then arises as to who will defend the judges. It must be for all of those involved in the law, including practitioners and academics. The legal system relies on confidence in the system. The third point I want to make is the importance of making sure that the rule of law is not to be confused with politics when it comes to the ethical duties of lawyers. It is important that the rule of law issues are kept out of differences between governments and that lawyers do not get caught up in the crossfire between states. All that judges can do is discharge their judicial duties in an apolitical manner. This issue is one of real concern, especially in the context of economic sanctions. Sanctions have become increasingly popular as a tool to implement the foreign policies of states. Lawyers can be affected by sanctions. It is sometimes difficult to obtain expert evidence on foreign law in the context of proceedings in England, where states have engaged in intimidation against lawyers who might act contrary to their interest by threatening them with sanctions or even criminal prosecution if they give evidence. Such steps are an attack on the rule of law and the freedom of the legal profession. It is not only individuals who are affected. What about barristers' chambers or law firms? There ought to be no place for sanctions against barrister chambers or law firms. This is particularly the case where the barrister is simply presenting a client's case as an advocate in the values of the bar. To target the chambers as a whole undermines the principle that barristers practice as independent practitioners, each under their own name and with a corporate identity only in the loosest sense, sharing costs but not revenues. This explains why it is common for barristers in the same set to appear against each other, using information barriers to preserve confidentiality. The idea of a collective responsibility for members of a chambers is therefore misplaced, and caution is required to avoid any misunderstanding in this respect. It is important that when chambers are marketed for business purposes, that the notion that barristers are acting as individuals is not lost. Although I focused on barrister chambers, the same principle applies to law firms, despite the fact that law firms typically share a greater corporate collective responsibility and corporate identity in a partnership. The final rule of law issue I want to address is the role of the Inn in speaking on such issues more generally. This is a difficult issue because the interests of its members may conflict. Its members include judges and barristers. Its members are not only based in England and Wales, but some may live and work abroad. Take, for example, the issue of whether the Inn should take a position on sanctions that have been imposed by a foreign state. Some members will be wholly unaffected by the steps where they have no assets or presence or family in the state seeking to apply sanctions. And where members are affected, it is difficult to take steps that might have adverse consequences for those members. It seems to me that there are two reasons that suggest a cautious approach is appropriate when handling this type of case. First, when a person joined the Inn, they did not do so on an understanding that they were joining a body that was politically active or would take a position that might have adverse consequences to them. Secondly, there are bodies that represent the bar in the sense I've just mentioned, the main one being, of course, the Bar Council. In summary, upholding the rule of law is a core value, or perhaps more accurately, a set of values that is rightly taught as part of the education and training of barristers. It is a core value that needs to be applied by all members as a duty throughout their membership of the Inn. I would argue that promoting the rule of law should be one of the aims of the Inn. The working group is right to focus on the rule of law. Others have done so too. A good example is the Flynn Foundation. It works across the globe to improve justice systems, provide judicial training, and foster human rights and the rule of law. The whole legal profession has a special responsibility for upholding the rule of law where it can, but it can give rise to difficult issues in practice for a diverse body such as an Inn, whose core functions, as stated in the standing orders, include a pastoral responsibility for its members and the provision of a source of wisdom and support when needed. These private pastoral responsibilities are not always easy to reconcile with a vocal presence in the public arena. I now turn to the important subject of diversity. This subject covers a whole range of issues. Diversity as a term covers a range of characteristics: gender, race, ethnicity, sexual orientation, disability, and social mobility. Tonight, I want to focus on race and ethnicity. I do not consider I have any particular expertise in discussing the diversity issue, although my background is multicultural. The starting point must be an appreciation that diversity matters. This is for many reasons. Let me briefly set out what I consider the main ones to be. First, there is a moral and ethical reason. As a matter of decency, we should treat each other equally. The inn describes itself as a part of an honourable profession. There is a strong moral argument to operate in a fair and just manner. Secondly, there is a question of merit. The bar is more likely to operate in the public interest and to preserve its reputation and role in society if it attracts the most able advocates, whatever their background. Thirdly, there is an economic reason. Bodies that are diverse tend to outperform entities that are not diverse. Diversity results in the best use of human resources. The promotion of diversity has become a business priority. Fourthly, there is self-interest. The users of legal services increasingly want to know how its legal advisors deal with social responsibility and diversity issues. Many clients hold their client advisors accountable for diversity performance. Diversity also raises regulatory issues, as recently pointed out by the Financial Conduct Authority. Understanding diversity is one of the competencies that must be shown when applying to become a Queen's Counsel. Finally, there is a matter of improving the job. Experience shows how rewarding it is to work with people of different backgrounds. I'm going to focus on racial diversity. There is an issue of terminology. It's become common to use the term BAME, Black, Asian, Minority, Ethnic. The problem with the term BAME is that there is a risk that it disguises the problem. It categorizes persons of color with different characteristics as if they are facing the same issues and challenges. It is deeply troubling that although progress has been made on some sections of BAME, people of Black background are particularly underrepresented. The particular underrepresentation of Black lawyers in the legal profession is deeply troubling. I've heard accounts from Black barristers saying how they know of persons who have been put off from seeking to become barristers. It is said that Hall in the Inn is full of paintings of distinguished lawyers, but no Black faces. They feel this shows that they do not belong here. They see the lack of Black barristers and solicitors who have made it to the senior judiciary. Becoming a judge is for many the pinnacle of a legal career. This gives the message that even if you get to the bar, you're not going to go far. Clients see the underrepresentation as an indication that Black barristers should not be retained. Horror stories are given as to how Black barristers are searched when they enter a court building and white barristers simply walk through. Security. They're treated as defendants and not as members of the bar. They are the victims of direct and casual racism. It's not only the bar that has issues, but also the city. It's recently been reported that the number of Black executives at the top of Britain's biggest listed companies have fallen to zero, despite public commitments to increase diversity in leadership. No Black chairs, chief executives, or chief financial officers remain in any FTSE 100 company. This is very damaging because it can signal to prospective candidates that their prospects of reaching the highest levels of an organization are poor. The pandemic has also had a disproportionate effect on minorities in terms of education, economic inactivity, and unemployment. Entry into the profession has also been affected. The Bar Standards Board has reported that there was a 35% fall in pupillage numbers in 2020. There is every reason to think that the pandemic will affect the number for 2021. The question then arises as to what the inn and the legal profession should be doing to promote the entry and advancement of talented people of colour, and particularly to increase the number of Black lawyers. First, there needs to be an awareness that there is a problem which needs to be fixed. It's not enough to say that you are someone who cares and is appalled by the lack of diversity. The issue is, what are you going to do to make sure that the bar is a genuine and open meritocracy and fully representative of society? Second, it must be recognised that being colourblind is not a solution. Frequently, this term is used with good intent, but it shows a lack of understanding of the challenges that exist for people of colour. Being colourblind also means that being blind to the significant structural challenges that people of colour face in reaching the same position in life as their white peers. This must be taken into account when making decisions about recruitment, work allocation, and promotion. It's important that those who are making the decisions that affect the livelihood of individuals form a diverse interview panel and understand the issues that need to be considered when making those decisions. Third, there must be an open discussion of the issues. They will not go away if there is no discussion. Many will go through their careers without any serious discussion of the issues. There has to be an acceptance that the discussions of the issues is not always easy. Innocent mistakes can be made when issues are discussed. There is a concern about using the wrong language or offending people. It is counterproductive to criticize someone for making these kind of mistakes. Instead, conversation should be conducted with an open mind, even when difficult or uncomfortable, so that we can all learn and develop our thinking. Fourth, some form of positive action may be required to accelerate change. The Bar Standards Board, in its anti-racist statement published in November 2020, indicated that there are circumstances where evidence-based positive action measures targeted to a specific group may be required and an intersectional approach should be taken. There is need for a well thought out strategy that is likely to include targets, but not quotas, and regular reviews of whether the goals are being met. When advertising for lateral hires and pupilages, chambers should be prepared to say that it encourages applications from underrepresented groups. It's important that even if positive action measures are taken, ultimately decisions must be merits-based. No one wants to get a job or position because of tokenism, but this does not mean that decisions on recruitment should not consider context. The bar requires intellect, emotional intelligence, open-mindedness, good judgment, and an ability to handle difficult issues. All of these qualities should be part of a merits-based assessment. Fifthly, members of the Inn should regard themselves as anti-racist and actively support those who have been affected by racism. The message should be given of the desire to do better. It's not about waiting to be approached before you do anything. It's about being proactive, listening, and showing empathy. It's about investing time in the future of our profession. In this respect, the BSP's Race Equality Task Force was right to launch the pilot of reverse mentoring scheme in which the bar students and pupil barristers from Black and ethnic minority backgrounds mentor senior barristers from white backgrounds. Efforts to bring about change should not be limited to measures concerning students and members of the Inn. This is too late. One of the weaknesses that exist is that because of the perceptions, many do not get as far as becoming students with an interest to pursuing a legal career or career at the bar. They give up or are discouraged from showing interest in the first place. This means that it is necessary to engage with pupils in schools and academies. It would be wrong to come away with the impression that nothing is happening in relation to diversity. Steps have been taken, but more needs to be done. The Inn is aware of the importance of diversity and is addressing the issues. For example, it has established an equality and diverse review that involves a review of outreach, scholarships, training, recruitment, committee composition, as well as the general environment in the Inn. It has changed the process by which masters of the bench are elected to ensure it does not unfairly discriminate or exclude. It has reviewed the methodology by which Inn scholarships are awarded. The Inn recently joined as a supporter of the Charter of Black Talent in Finance of the Profession. The impetus behind the Charter is the promotion of Black talent in the financial and professional services sector. The Charter stresses the importance of collecting data on which organizations can assess progress on this agenda. There will be independent monitoring. It points out that in October 2020, out of 593 barristers in the 6 sets described by the Lawyer magazine as magic circle sets at the commercial bar, there were only 5 black barristers. All the inns are major supporters of the Charter, as is the City of London Corporation, the Commercial Bar Association, the Bar Council, and others. A number of leading law and accountancy firms have agreed to become signatories to the pledges in the Charter. Social mobility is important if diversity is going to be achieved in a meaningful way. This involves contact with schools. Griffin Law and Advocacy Workshops is the inn's vehicle for promoting social mobility and access to the bar. The inn also operates a Griffin Access Programme, which was realised by an initiative through the City Working Group. And this is in its 2nd year with the Newnham College Sixth Form by way of a pilot scheme. The working group has a common interest in outreach. The group can find ways of reaching out to more schools. One positive aspect of the pandemic is that it is easy to put on webinars at low cost. There is no travelling time, cost or hassle in getting to an event. There is no restriction on the number of attendees. And this opens the possibility of communicating with schools and getting across the message of the importance of diversity and inclusiveness. The inn takes pride in the comradeship and the interest of its members, one in another. It needs to get this message across to students who may have no contacts or support. This will involve giving the opportunity to shadow barristers in court, in mentoring and encouraging barrister chambers in giving paid work. Ideally, it will involve modest scholarships to assist in paying living expenses during university. It is all about giving confidence and familiarity about the way the bar operates to young people who have no legal networks. It's also right to record other initiatives which deserve support. Bridging the Bar was launched just over a year ago to support students from non-traditional and underrepresented backgrounds to access the bar. 6 commercial sets have set up a scheme called Mentoring for Underrepresented Groups, a scheme run by Commercial Barristers Chambers. Mentoring is important. It is something that has a place at the time of entry into the profession, and also in the early years of practice. There is a good argument to say that the mentor should not be in the same set as a mentee, and the inn should consider setting up a scheme for those who will benefit from it. There's also a need to increase the number of pupilages. This is a matter of considerable importance. There's no point encouraging students to become barristers if the prospects of getting the pupillage are too low. Thought needs to be given as to how this can be done, and in particular whether it is possible to increase the number of pupilages at the employed bar by encouraging arrangements between employers and chambers. The impact of the pandemic is not the same across the bar. The impact has been severe on the public funded bar, where pay levels have been too low for too long, and where the pandemic has made it difficult to conduct jury trials because of the needs of social distancing. Many commercial sets have been able to maintain work levels as they've mastered the use of virtual hearings. It's right, therefore, that several commercial sets have agreed to fund criminal pupilages, which otherwise would have been lost because of the pandemic. This is all consistent with the one bar philosophy and the public interest in a strong criminal bar. The Inn and the City Working Group has a common interest in promoting diversity, especially in relation to underrepresented groups. This involves making public commitments to diversity, but also action along the lines referred to above. It involves gathering data that will show what is being achieved. Attitudes need to change, and attention needs to be focused on pupils in sixth form, on students, and those starting their careers. Access to justice is the next topic to consider. In a broad sense, this means that legal institutions are available to ordinary citizens so that disputes can be peacefully settled and rights can be vindicated and protection be provided against abuses and public and private powers. An important aspect of the rule of law is access to justice. If ordinary people cannot access justice, then the law is irrelevant for them. Those who may have been wronged will escape the legal consequences. Access to legal services by those who need them is fundamental to the rule of law and the preservation of liberty. A legal system that serves some groups of people better than other groups is unlikely to command public confidence and respect. It's worth recalling that matters relating to family, homes, and life savings, which might be perceived by commercial lawyers as low level, are not to those involved. These kind of issues will have considerable importance and relevance to those affected. The case for pro bono work is compelling. Pro bono work helps people to access justice. Often these people will be in very difficult circumstances, for example, facing bankruptcy or the loss of their home. They will not be able to afford lawyers, but expert legal advice and representation in legal proceedings can help them to achieve a just outcome. Without lawyers, litigants may not be able to focus on the essential points. The judge is then left to deal with the case with little assistance. With pro bono lawyers, the process is more efficient and more just. There are also wider benefits. Someone who cannot access justice may become more dependent on the state, perhaps for housing and other benefits. With access to justice, that person is more likely to become socially and economically productive. So the case for supporting pro bono is overwhelming. Barristers have an obligation to make sure that legal services are available, which is in conjunction with and not as a substitution for the government's role. They're given rights of audience, and this gives rise to special obligations to help the have-nots. Here again, the public interest is in play in the commitment to public service, which enhances the reputation of the profession. One of the themes of this lecture is the international reach of the in and the legal profession. An example of this is the International Advisory and Dispute Resolution Unit, IADRU, at 3 Verulam Building, the chambers where I practice. This unit has been set up to provide advisory dispute resolution and pro bono services in developed and emerging markets. Social responsibility is the core of IADRU's outlook, and this includes pro bono work around the world for states. IADRU's focus is complementary to Goal 16 of the United Nations Sustainable Development Goals: peace, justice, and strong institutions, including promoting the rule of law and access to justice. It's right to record the important work done of Advocate, formerly the Pro Bono Unit, and LawWorks, the Solicitors Pro Bono Group, in the provision of free legal advice. And of course, the 4 Ins make a substantial payment to Advocate. So the case for the members of the Inn to be involved in pro bono work, whether domestically or internationally or both, is a strong one. There is a debate, particularly in the United States, as to whether it should be compulsory for members of the legal profession, with a buyout option for those who lack the time or the inclination to participate. To be admitted to the New York bar, an attorney first must have completed 50 hours of pro bono work. I do not believe it right to force lawyers to do pro bono work. However, it is consistent with the values of the bar and the public interest that this work should be done. And the Inn should set the example by encouraging those sets in the Inn to set the example and create a culture where some pro bono work is done during pupillage. The final topic to consider is the international market for legal services. The UK is the leading international financial centre. The courts in the city operate together. English common law provides a legal framework which is reliable and respected. It provides for legal certainty, and in the main it is up to the parties to agree how they wish to regulate their relationships. English law is the law of choice for business and cross-border contracts. The independence, integrity, and legal excellency of the English judiciary are undoubted. London is also a leading arbitration centre. The Arbitration Act of 1996 has worked well. It respects the autonomy of the parties, and there is a light touch to judicial supervision which aims to support arbitration with limited grounds for challenging an award because the parties want finality. However, remaining the leading centre for dispute resolution cannot be taken for granted. The focus of this concluding part of the lecture is on the international reach of English law. Globalisation has made the world a much smaller place and a much easier place to do business on a huge international scale. Recent years have seen a substantial increase in the founding of international commercial courts and arbitration institutions. What is driving the creation of these bodies is the desire to encourage investment. The rule of law comes into play whenever there is an increasing investment because businessmen want their cases tried according to the rule of law and by independent judges. The growth of new court and arbitration centres brings intense competition in a field which is commonly thought to be rather staid. That is no doubt a good thing for the parties, judges, and the states concerned. For the parties, this means that there are more options as to where and how disputes can be resolved. Judicial interest in the topic is clear. An example of this is the Standing International Forum of Commercial Courts, which was launched in 2016 by Lord Thomas, the then Lord Chief Justice of England and Wales. It enables commercial courts to swap ideas. Its explicit aims are sharing best practices to promote positive competition and the rule of law for the benefit of all. States also see the benefit of a healthy legal sector through court fees, taxes, hospitality, investments, and international prestige and leadership. This growth of competition provides an impetus to change. The English courts are undergoing a £1 billion modernisation programme to bring them up to date, particularly to make better use of technology. There is an online dispute resolution for small claims and is likely to become available for commercial disputes. Over the past 10 years, there have been important reforms which have affected hearings and improved access to justice. At the same time as the court system is improving in England, there's been a growth of international courts. In Europe, English language chambers have emerged in Frankfurt, Hamburg, Paris, and Amsterdam. In Asia, the Singapore International Commercial Court has shown that a top quality commercial court can go from zero to up and running in 2 years from its announcement. The Singapore International Commercial Court has a mix of judges from common law and civil law jurisdictions. China has launched the China International Commercial Court, which includes an advisory international commercial experts committee chosen by the Supreme People's Court of China. In Kazakhstan, the Astana International Financial Center, the AIFC Court, provides a common law court system based on principles of English law. It has exclusive jurisdiction over disputes arising out of activities and the operations of the AIFC, and jurisdiction in case of other disputes by agreement of the parties. In the Middle East, the Dubai International Financial Center, DIFC courts, has shown that a common law court can be created within a civil law and even Islamic law state if that's what businesses need. Qatar has the Qatar International Court and Dispute Resolution Center, which offers both court proceedings and purpose-built arbitration facilities. In Abu Dhabi, the Abu Dhabi Global Markets Court operates a legal framework which involves the direct application of English common law. What do these developments mean to the inn and the legal profession? First, it's important to recognize the existence of a competitive global legal market. Positive competition between courts, as opposed to a turf war, is a good thing. No court system can afford to be complacent. Courts need to watch out for new developments and be looking for ways to improve. This must be good for the rule of law and for business. London prides itself as a leading arbitration centre. This is unaffected by concerns about Brexit. The Inn and City Working Group has an interest in promoting English law and jurisdiction. Active consideration needs to be given as to how this can be done. It is often said that the choice of law or jurisdiction clauses in a contract tend to be agreed by the parties at the last minute. Although there is a tendency to focus on the role of barristers as advocates in court or before arbitral tribunals, there are many barristers who are employed by companies, and they may have an influence on advising their employees on these issues. It's important that the Inn engages with all its membership. Secondly, the direct or indirect influence of English law is ever present in the new courts. The procedural framework under which some of these courts operate refer to principles reflecting the overriding objective. Barristers and other English advocates can appear in some, and as I mentioned at the outset of the lecture, virtual hearings are likely to become the norm for routine hearings. There may be challenges in terms of time zones, but there is every reason to think that proceedings will be conducted efficiently by participants who are based in the UK. For longer hearings, the court and the parties may want in-person hearings. Hybrid hearings, with some attending in person and some remotely, are also likely. The wishes of the parties are likely to drive the form of the hearings in the new foreign courts. One of the features of these courts is that English judges who have retired from full-time judicial office are frequently appointed because of their skills and standing. By accepting an appointment in a foreign court, the judges are required to operate within the legal framework of that jurisdiction. English judges sitting in the new courts will expect the same standards from advocates as if the cases are being argued in London. This can only be good for the reputation of English law and English lawyers. It should not be overlooked that it is a privilege to appear in courts outside the United Kingdom. One issue that has been discussed is whether, if there are rule of law concerned in the state where the foreign court is located, it is wrong for an English judge, even if retired, to sit. The concern is by sitting, the judge is condoning or turning a blind eye to issues that go to the rule of law. Clearly, each judge will have to make up his or her mind as to what is appropriate, and those who choose to sit deserve support. As I mentioned above, no state is immune from criticism that it breaches principles of the rule of law. As far as I'm concerned, the critical issue is whether judicial independence is respected. If there is judicial independence, the fact that the state may be subject to rule of law criticism is unlikely to be relevant. The rule of law is not confined to democratic states. By serving as a judge, he or she is not condoning the state's other activities or the practices in different unrelated courts within the state. Although judicial independence is critical, it may not be enough. The example that comes to mind here is where the judges are required to enforce laws that are so morally objectionable that it would be against good conscience to apply them. In the new foreign courts, whose jurisdiction is limited to commercial disputes, and where there is no criminal jurisdiction, it is difficult to see how this consideration could ever arise. A criticism that has been made of the foreign courts is that the state concerned is presenting a two-tier justice system where the state quality of the judicial decisions is very different. One tier is concerned with the national judges and the other is made up of judges from abroad. This criticism is unfounded, but this criticism is met by ensuring that the courts abroad, which apply common law principles, engage national judges to sit with the judges from abroad. The shared experiences between judges appointed outside and within the state are important. All can learn from each other and all can benefit. It's important to engage with lawyers in the foreign jurisdictions. With the benefits of the new technology, this can be done without international travel. It is easy to arrange webinars of mutual interest. We have a lot to learn from each other. As to judges, consideration should be given whether it is possible to arrange for them to come to London and to gain experience that they can apply in their own local courts if they so wish. They will be welcome in the inn. For students, the ability to communicate virtually means that it is possible to do events with other students around the world. In the inn, we recently had a debate with the American Inns of Court. The WC-Viz International Commercial Arbitration Moot took place virtually earlier this month. The inn was represented by students: Jocelyn Lim, Matthew Ennis, Casper Ramsey, Alice Horn, Emma Kelly, Ingrid Griffiths, and Johnny Pilkington. They were honourable mentions for Best Team and also Best Oralist for Alice Horn and Matthew Ennis. Contact by students across borders is exciting and can only be good. In conclusion, I hope I've been able to show that the role of the inn and its members goes beyond its historical function concerning education and training of aspirant barristers. I've suggested that there are broader moral values and a public interest that are in play. This can be seen in the rule of law, diversity and inclusion, access to justice, and the international reach of English law. I suggest that the time has come when we should affirm these values by recording them in the inn's standing orders. There are many advantages of doing this. For one, it reflects what is happening already, and in particular, it will confirm the inn as an institution that operates in the public interest beyond the education and training of aspirant barristers. It will bring together all its members in respect of shared values, and this must be good for all. The notion of members of the Inn working with the City of London Law Society is extremely positive and welcome. I hope this lecture will give some ideas on what can be achieved going forward. Thank you for your attention.
Thank you very much, Ali. At this point, there would be applause in a live lecture, but I'm afraid you'll have to pass on that. We have a number of questions in the chat box. Ali and I are prepared to answer those questions. We may run on slightly. I noticed that some of the questions are more sort of personal statements. They will be registered in the chat by the Inn and no doubt can be addressed by the Inn as appropriate. But let's try and get through as many of these questions as we can in a reasonable time. The first one, Ali, deals with the rule of law. Given the perceived need for caution, what more do the panelists feel the Inn can do in practical terms to promote the rule of law? What you might want to link that to the question of the role of access to justice in the context of the rule of law, and the fact that realistically most people in this country can't afford access to justice. What can the Inn do? And if you answer that question, I might chip in a bit from the city.
To me, the real question is to recognise the importance of the rule of law and to get the message out to the public. And I think what that involves is perhaps organising webinars, discussions, talking to people, and particularly interactions with lawyers from abroad. Because I think part of the problems that have arisen, and there's been various debates this year that I think we're all familiar with, I think there's just a misunderstanding about what we can and cannot do. But I accept the point that the rule of law does involve often political issues. But the point I was trying to make in the paper, and which I don't think has been understood by everyone, is that when it comes to the ethical duties of advocates, solicitors, is that we need to keep politics out of the debate as far as possible. So I think the answer to your question is that we need to promote it. Perhaps there needs to be a lecture which is specifically directed to the rule of law. We need to interact with foreign lawyers, and that ties in with my point about the international reach of English law by linking up with lawyers from abroad. And as I say, doing seminars, something that we would never have been able to do before. I mean, if we were to go to Malaysia, we'd probably spend days going out there, recovering from jet lag and coming back. Whereas we can put on these webinars at very short notice. They don't cost very much. And I think it's a great way of getting our values across.
I think your point about foreign lawyers is a good one. For anyone who's been to Runnymede, the constructions there funded by American lawyers in recognition of the role that Magna Carta played in the rule of law are extraordinary. I sometimes wonder whether actually we misunderstand the rule of law, or rather foreign lawyers understand the rule of law better than we do. I'm sure public legal education is part of it. Pro bono is part of it. I think the bar, city lawyers, the Inn, encouraging politicians not to take cheap shots at lawyers and judges is part of it. And I'm afraid, from my point of view, I think more money in the publicly funded sector is important. Let's move on to another question. Are issues such as collective responsibility, independent practice, cab rule, rank rule, etc., misunderstood because barristers and their professional organisations have failed to adequately and frequently explain them?
Yeah, I think the answer is yes. I think I mean, to some extent, we're at fault ourselves. I mean, we say we're sole practitioners as we are. We do cases against each other, but I mean, when I started, I don't think we were even allowed to have business cards. Solicitors weren't allowed to come to. We weren't go to solicitors' offices. I mean, the good old days. I mean, it's changed so substantially, and inevitably, chambers start to present a corporate image, And I think that is the problem, that we present this corporate image and it gives rise to confusion. So I think the answer to the question is, we just have to keep on stressing that we are independent. And as I said, there's a real role for education. I mean, we've seen it in particular in the context of arbitration, where it used to be perfectly understood that barristers could appear against before an arbitrator who was in the same set, the case of Lagana Airways. But it's not really understood by everybody, and there's normally a fight when that happens, and it's suggested that a barrister can appear before somebody in his or her chambers. But I think the question is right. It is important to get the message across. It clearly isn't understood by everybody, and I think when it comes to marketing, we just have to make it very clear what we're doing. That we still remain sole practitioners, and that's the fundamental principle. So I think, yeah, I agree with the question.
The next question, I would like to ask whether the proposal by the Clerk's Room in establishing a charity offering pupillage is seen as a positive step forward towards tackling the issue of diversity at the bar.
So I missed that. Can you just repeat that one again?
Yeah, I would like to ask whether the proposal by the Clerk's Room in establishing a charity offering pupillage is seen as a positive step forward towards tackling the issue of diversity at the bar.
I have to say I haven't come across that proposal, but it sounds good. I mean, anything that is going to generate money for pupillage is a good thing, and that's why I was particularly impressed that the commercial sets stood forward and helped by providing pupillages for criminal sets who otherwise might face difficulties. I've always believed, and this is a fundamental principle as far as I'm concerned, that the criminal bar is absolutely fundamental to everything that we do. And the commercial bar has been fortunate in the sense, as I said in the talk, we've been able to keep going. We've been doing hearings. I mean, I've been doing hearings starting at 7 in the morning, and in one of them, the arbitrator was in Australia, finishing at 3 in the morning. I mean, we're working in a way that we've never done before. And frankly speaking, many of us are working harder than we've ever worked before. But the point is that, and this is the key point, the criminal bar, the publicly funded bar, is not in the same position. And therefore, it's only right that the commercial bar should come forward and support the criminal bar. And that comes to everything as far as I'm concerned. So the suggestion about Clerk's Room, which I didn't know, is positive. And certainly in my mind is a great development.
Yes, and I mean, it sounds as if that parallels a number of initiatives that city law firms are undertaking to improve social mobility, diversity, and looking at how one might support some of the publicly funded areas where the CLOS are currently looking at whether we can find some way of producing a scholarship fund to support those working in the social sector of the law. Right, next question, and we're moving now into your comments about diversity. No question, but I am grateful that the colourblind issue was raised. And then it says blind sift equals colourblind. This pupillage application process does not help those in minority groups, especially black people. The whole system needs to be restructured. I suppose what that means is by making things blind, you don't perhaps pick up the fact that the applicant may be in a black and other questions relate to other minority groups.
Yeah, I think that's right. I mean, I have to say that the question is a good question because it's something that I've thought about, which is how do you get the points out if it's blind? But my understanding, and I have to make a confession here, I actually haven't seen the applications, but understanding how it operates at 3VB and in the inn, is that there are scopes when you make your application to point out what I've described, I think, in the lecture as context, about points that you want to bring out about your personal circumstances, which are relevant to be taken into account. So I take the point that being blind in terms of the interview process, taking the names out, which I think is quite common now, but there are ways of getting the points across in other ways, in other places in the application form.
There is a later question which makes the point that if the focus is on one area of diversity, you don't deal with other marginalized groups. I think, to be fair, Ali, you were taking the black minority as an example, not exclusively.
Yeah, I mean, I think again that's an important point which I'm very conscious of, which is we have to recognise diversity across everything, and it's important that attention is given to all groups, and that's something that I need to do in the rest of my year to make sure that we do have events that cover, LGBTQ plus and gender issues. Well, to some extent, perhaps gender's already been covered, but it's absolutely right that that it would be wrong to focus on one group with characteristics without looking very carefully across the board, and I agree with that.
The next question, perhaps I can lead the answer on this. I have a question. What is the view on the EU's intention to oppose UK's admission to the Lagana Convention, as it would be a blow to our legal sector? We don't yet know what the EU's, I think here is the Commission's intention is. The Commission apparently up to now has taken the view that Lagana is one of the benefits of being a member of the EU. But I'm told that the decision by the Commission will not be known until probably June. A number of EU countries are in favour of the UK joining the Lugano Convention, and the vote will in Parliament, EU Parliament, will be a weighted vote. So I wouldn't yet assume that UK will not be able to adhere to the Lugano Convention. Even if it can't, that is not the end of the world. The Hague Convention of 2005 is not a perfect answer because, first of all, it deals only with exclusive jurisdiction, and secondly, because there's a difference between the UK and the EU as to what date we would join by. The EU's view is we would only join by the beginning of this year, as of the beginning of this year. Although obviously the UK takes the view that we would join as of when the EU joined, of which we were a party. And Hague 2019 is in a sense a long way away because people have not yet acceded to it. But without any of that, we mustn't forget that we've operated for a long time with enforcement of judgments and other matters with jurisdictions other than the EU for many years. And there are bilateral treaties with Italy, for example, which can be used. It's not going to be helpful for EU businesses, for EU members, and for EU individuals. The people who are likely most to suffer are individuals, families, and SMEs, because the cost and complication of enforcing judgments and avoiding duplicative proceedings will inevitably grow. Big businesses and rich individuals, that will be a marginal cost. The people who will suffer will be the smaller people, to use that rather pejorative term, and there will be mutual disadvantage to the UK and to the EU. I don't know whether you want to add anything to that, Ali.
No, I mean it's obviously a very topical issue. I tend to think, first of all, arbitration is fine and unaffected.
Yep.
You've also made the point about the Hague Convention, which is very important. But I think people are just going to have to grow up and come to do the obvious, because the Europeans will want their judgments enforced here and vice versa. So the commercial logic is that Lugano, will get agreed. It may take a bit of time to get there, but I think in the long run, it will not be an issue and will get sorted out.
And I suppose the point that mustn't be missed is that none of this affects the attractiveness of English law as a law for business and other disputes. Then we have, right, would it be fair to say that a person predisposed to discriminate against another on the basis of one characteristic will likely be disposed to discriminate on the basis of a different characteristic? I suppose the answer to that is yes. If yes, then I would hope that all of the characteristics on which discrimination is founded to receive similar, if not equal, concern. I think you've dealt with that question, Ali. Similar, if not equal, concern and coverage, disability and age, amongst others, come to mind.
Absolutely, I agree.
There's then a question about, there's a statement about other minority racial groups, which I think, again, you've dealt with. There's then a question of, well, the question is, what is your guidance when reporting issues of racial discrimination, and the relevant authorities, what you've called colourblind? This came off a situation where there was a wanting to report a discrimination where the use of the word black was criticised. I don't know whether you've got any views on that, Ali.
Well, I mean, one of the points. I mean, there is going to be a paper, which I think probably going to be circulated tomorrow, where I go into these issues in much greater detail. I've had to cut down a lot of what I would like to have said, obviously, to fit within the time. But I think this point about speaking up is very important. And I do cover that point in the paper, and you should be able to read that to see what I propose. But I mean, speaking up is important. I don't think people should be afraid to speak up. They should be encouraged to speak up. And I think also that another point that perhaps I've made in the written paper is that this is not an issue that's just, you know, for the people affected. It concerns everybody. This is a problem that we've all got to fix.
Okay, then there's a question about verbal abuse, linked perhaps to a question about what can be done to educate members of the judiciary about diversity. I guess this is simply not an issue of attracting black and other minorities to the bar, but ensuring that within the profession, black barristers can be treated with dignity and respect to discharge their professional duties. I guess this is a question about some of the recent press reporting of judges being harsh on, well, women and others.
Yeah.
I mean, I think the answer to that, the question answers itself, probably.
Well, I think the judges are taking it seriously. There's training. I think they're alive to the criticism, and I think everybody realizes that, you know, we can all improve.
Ali, there's thanks for your interesting and insightful presentation, linked to a question about the role of the UK courts post-Brexit. How important for the UK legal system and the UK courts is the UK signing up to the Lagana Convention? I think we've talked about that. I mean, I agree with you. I think the logic, because Lagana is an entirely mutual benefit, and those that will suffer will be mutually EU and UK cited. Next question. I'm also of the opinion that pro bono work is integral to widening access to justice. However, it is with some irony that the emphasis on accruing substantial hours of pro bono work prior to pupillage serves to narrow access to the legal profession itself and reduce diversity. Extensive voluntary work can be unfeasible for many students juggling expensive legal studies and paid employment. I'd be really interested to know your thoughts on this subject.
Yeah, well, I mean, where I came out is I was just really looking at the American experience, because my understanding is that it is compulsory, certainly in some states, but where I come up is the conclusion that it shouldn't be compulsory, that it should be voluntary. So I think if you have got, you know, if you are unable to do it at a particular stage of your career, because you haven't got the time, because you've got other commitments, because you haven't got the financial resources, that's fine. But where you can do it, I think, the message that I'm trying to make is that it is a good value, and it should be something that we should all be doing if at all possible.
There are many statements of support for what you said, Ali. I won't read them all out in the interests of time. Another question. Unfortunately, I'm aware of very reputable lawyers who were detained in Belarus. I was very disappointed to be unable to obtain support in the UK for them. When I spoke to the Bar Council in the USA, they immediately became involved. Perhaps we can do more for lawyers in other jurisdictions.
Yeah, I agree. I mean, I think as I said, the difficult thing is where your membership may have conflicting interests in terms of what the right response is, and I think we all know what those issues are. And I think in answer to Arya's question, it seems to me that the Bar Council is incredibly well placed to make statements on behalf of the profession generally. It has a committee that focuses on human rights issues, and they are prepared to speak up, as we saw yesterday.
I'm conscious that we're 15 minutes beyond time. Let's press on for a bit longer, but at some point we will need to guillotine. We're having questions are rolling in, which is a good thing. Ali, I have a question as to whether the rule of law can be consistently explained across the globe. Foreign lawyers often have very contrasting views about the rule of law in different parts of the world. Should we look for a more diverse approach to the theory?
Oh, that's a very good question. I mean, what I was actually when I was researching for this, I was quite interested to look at the differing notions of rule of law. And the question is right. It isn't the same. And I think one of the advantages of Lord Bingham in his attempt to break it down into propositions is that he's coming up with propositions that few can disagree with. I mean, you can disagree, and of course there are disagreements, and a lot has been written about what the rule of law represents. But if you take, for example, China, they have a completely different view about what the rule of law means. For China, independence of the judiciary is not an aspect of the rule of law. And there have been a number of statements at the end of last year and the beginning of this year where this particular topic has been addressed. And I think if you are interested in researching the point, you will find this topic has been discussed, and that there are clear differences between notions of what the rule of law and what it actually means. But I think all we can do is try and focus on the core issues, and I focused on some of them today, with a view to recognizing that it is to some extent a concept that is difficult to define precisely, but recognizing that it does have some utility, and trying to work out what the core values are and what it represents, and seeing what we can do to promote them. And to some extent, it's always an ideal. I mean, as I think I said in the lecture, you can see, there's a rule of law, the sort of index where states are ranked, so to speak. Everyone has rule of law issues. They may differ, but that doesn't stop one in trying to focus on the fundamentals, which I've tried to outline this evening.
And I mean, as you said earlier, I think there is something to be said for selling or marketing the rule of law in this country. Public legal education is something that comes onto the government's agenda from time to time. I think perhaps that may be something the Inn and City law firms could jointly work on. Next question. Ali, would you suggest replacing BAME with something else, or completely cancelling the ability to refer to a group of marginalised people?
I mean, it's really difficult. I mean, I forget what the phrase is at the moment. I mean, the problem of phrases is that it changes all the time. I mean, when I became applied to be a recorder, I think in 1996, the bar tended to break down into white and black, and that was it. It was like it was a distinction. So I was black, which of course sounds ridiculous, but that's the way it was. Apparently, I'm now brown. Now, I would never have called anyone brown 3 or 4 years ago. And I think what this really illustrates is the fact that this terminology is constantly changing, and it's quite difficult to keep up to date. I mean, some people, you know, clearly we would never refer to somebody as being a colored person, but it's acceptable to refer to persons of color. And you know, it is hard to get the wording right. One has to be flexible, and that was the point I was trying to make in the lecture, which is, you know, let's have discussions about these issues. And if we make mistakes in terms of terminology, don't criticize that person, just correct them and come up with the phrase that you think is the right one. But I think BAME is the one that's really fallen off the wall, so to speak. Finding the right substitute is perhaps more challenging, but we need to think about the right phraseology.
Okay, another Brexit question. After Brexit, jurisdiction rules are now governed by common law rules, CPR rules, and Hague Convention. That's 2005. Right? Is that right? The answer is yes, until Lagana comes along. And there are a number of bilateral treaties, but they're very old, so you have to do a lot of research. There are a number of statements about people having suffered prejudice, being shouted at, and what have you. I think we've covered all of the questions. So I think all that remains is to say thank you again, Ali, for your work and for your interesting and stimulating lecture. The fact that we're still going well after time endorses that. And to everybody else, thank you for attending. And I look forward to this lecture in a year's time.